Make sure I don't ring myself here.
I've set up this. Chas doesn't have any slides.
Do you guys want to sit next to each other?
No,
I'm
no,
happy
no,
to
no,
sit.
no, I'm fine. I'm just remember who has slides. Stephanie has slides. Steph, are you there? No, here's the mic. Steph, I've got all the slides set up here, so just ask me or give me a visual, an auditory clue of when you want to refer to your slides or change them, and I'd be happy to. They're right on this computer right here.
Okay, I think I just had a recent study, so.
Oh, they got like a whole little thing going on here.
Well,
A little camera is like.
the camera's on us.
That's awesome.
So they can see.
Okay,
But we were having
I
visual
think we've
problems,
got
so they
yours
can hear
going.
us.
So,
They can only
okay,
see us
I'll
coming
just
in and
put
out.
the
They're on
on
that
that
screen
slide.
and slides
So
on
you're
that.
ready
Oh, that's
to
awesome.
rock and roll. Your slide is up.
That's great.
Traditional firm with virtual law office.
So you want me to go ahead and discuss, not just about myself, but talk about virtual law practice?
Let me start with some introduction, Stephanie, and then I'll talk to you about you, and if you can use it as a segue into the virtual law office, that would be great.
Got it.
Okay?
Great. I'll try not to muck up your slides.
And if we do, there's nothing you can do about it.
Well, one of the lessons we've been learning about technology is he or she who controls the computer actually controls the presenter.
That's
So
right.
in that respect, at least. Welcome back. The final panel for today's discussion takes us in a slightly different direction and convenes a group, as I've introduced and suggested, that are on the forefront of dealing with the challenges and the opportunities arising as a result of technology in legal practice. And it's a real privilege to have all of them with us. Two are joining us by Skype, although group Skype apparently is acting up this morning, so we're discovering some of the limits of technology, but we know that we have them by audio and the occasional visual. Stephanie Kimbrough from Kimbrough Legal Services in the Virtual Law Office is one of the ABA's recognized as one of the ABA's legal rebels. She's operated a web-based virtual law office in North Carolina since 2006. Specializes in estate planning, small business law to clients online. She was the recipient of the 2009 ABA Keene Award for Excellence in E-Lawyering and is an author of Virtual Law Practice, How to Deliver Legal Services Online, published by the ABA's Law Practice Management section in October 2010. Joining her on Skype is Mike Downey, who is a partner with Hinshaw Culbertson and is the former chair of the Ethics and Technology Committee at the ABA Center for Professional Responsibility. Mike's a litigator and a partner in Hinshaw's National Lawyer Ethics and Risk Management practice. He focuses his practice on advising law firms and accounting firms regarding legal ethics and risk management issues. He's been an expert witness, defends lawyers against civil and disciplinary claims, and he also lectures at Wash U and St. Louis University Schools of Law in St. Louis. He's a recognized authority on legal ethics and law firm management issues and actually published a new book that's out, Introduction to Law Firm Practice, again published by the ABA's Law Practice Management section in 2010. Joining me on stage are Dave Bilinsky and Chas Rampenthal. Dave is a practice management advisor and a staff lawyer with the Law Society of British Columbia in Canada. Again, the Canadian conspiracy continues. He lectures at Simon Fraser, teaching an online graduate level course, but like me, he actually spends a lot of time in the cross-border world. I like to say that, as Canadians, we speak fluently bilingual Canadian and American, same language, different dialect. And he's a past co-chair of the ABA's Tech Show, which is actually happening this weekend, chair of the Pacific Legal Technology Conference, been called upon, as he puts it, from Shanghai to New York City, from the Yukon to deep in the heart of Argentina, by law firms and law associations in terms of personal productivity issues, change management, and technology implementation, amongst other things. And Dave brings a wide variety of both regulatory and direct tech experience, and we're delighted to have you with us. And finally, last but certainly not least, Chas Rampenthal who is VP General Counsel of LegalZoom, about which much has been discussed already and much more will be discussed. He's been LegalZoom's VP and General Counsel since 2003, and he'll tell you more about LegalZoom during his discussion. He's an active member of the ABA, served on a number of committees, including the e-lawyering task force. Prior to joining LegalZoom, he practiced corporate litigation in corporate law in Boston and litigation in Los Angeles. And before becoming a lawyer, he served his country in the U.S. Navy in Operation Desert Storm. So, Chas, it's great to have you with us.
Thanks.
Thank you to all of the panelists for joining us. And the format for this discussion is going to be slightly different than the previous two presentations this morning. What I'm going to ask each one of the panelists to do in turn is to introduce themselves a little more than what I've provided you and talk to you about their interests and their experience with technology in practice settings for about 5 minutes or so each, and then I'll come back to some questions that I'll pose to all of the panelists generally, some specifically, and then turn to you for a more interactive session than the previous two panels were this morning. So with that, let me turn to Stephanie first. Stephanie, thanks very much for joining us. Why don't you tell us about your practice and the virtual law office and what you've been doing since 2006?
Okay. Well, I started out practicing in a small law firm that did commercial real estate. And we would do a little bit of estate planning, corporation setup, on the side, like a lot of general practice, small firms do. And about once a week, we would get these phone calls from folks who just needed basic legal services handled, and we couldn't refer them to legal aid because they didn't qualify for legal aid assistance. But we also, it really wasn't worth our firm's time to, the billable hour system, to bring them in, meet with them in person, and work with them. So seeing these people and knowing that there really wasn't anybody to send them to where they could get affordable legal services from an attorney or identified a market need. And my husband, I happen to look out there, is a computer programmer with a background in security. So the two of us collaborated for about a year to create a software program that would allow me to work with this particular consumer who's lower to moderate income means to deliver legal services to them. So after about a year in 2006, I launched a website that had a secure client portal, and I was able to deliver unbundled legal services completely online. So I do estate planning and small business law to my client, and I communicate with them through the secure client workspace, but then we also do web conferencing when they want to see me face-to-face or phone. It really just depends on the client, but that's how I built my practice, and it took about a year to sort of build a steady online client base. But after the first year, other attorneys started contacting me wanting to do the same thing and to deliver legal services online, either completely online like I do, or in addition to a more traditional law practice. So from there, I've just sort of been consulting and providing assistance to other attorneys, and along the way doing writing and teaching about the technology and ethics related to that online delivery.
Great, thank you. We're going to come back to talk a little bit more later on about what exactly unbundled legal services are and how that's transforming the way in which access to justice is being increased. But before we delve into that a little further, Mike, to you about your practice and your work with the ABA and others on tech issues and what you're seeing in terms of the transformation, some of the issues, some of the challenges as you're advising lawyers and law firms.
Sure. Well, Hinshaw Culbertson has probably the nation's largest legal ethics and risk management practice. We have about 12 lawyers who spend all or virtually all their time advising law firms. We do work for 100 of the firms on the analog 200. So you certainly have a very large presence and activity in the space. And my particular focus is focused on advising firms large and small on a variety of issues, including technology. In that work, I have done everything from defended a lawyer, actually a couple of lawyers who've been charged at various times with unethical conduct on the internet, including related to alleged misrepresentations in online advertising. I've done a lot of advising law firms with regard to their websites, and do a lot, frankly, in the space particularly of what should law firms be doing to create a more secure setting for their data, for their communications with clients. And that really, frankly, has become really an interest of mine. So I do a lot of teaching in the area of social networking and advertising on the internet, and I do a lot of work related to data security. And frankly, Missouri is not a leader in many things, but we are a leader in regulating unbundled legal services. And so more recently, that's been something I've been working on. And I know there's an article included in the materials that gets into how Missouri's rule deals with one portion of the risks, but frankly doesn't deal with all the risks that a lawyer may face if they're engaging in practice of law using unbundled services.
Well, that might be a neat break point, actually, to ask you both, and Michael, go back to you first for a bit of a definition and explanation as to what you mean by unbundled legal services and where the Missouri approach is actually moving forward and some of the issues that you see as problematic or potentially helpful about it. And then Stephanie, I'll go back to you for comment on that. So Mike first.
Sure. Well, unbundled legal services and limited scope engagements, at least in my world, are very similar. A limited scope engagement is that a lawyer agrees to take on a portion of a client's matter, but not the entire matter. For example, the lawyer may agree that they will file the petition, they will try the case and perhaps take the depositions, but with regard to producing documents and discovery or filing motions, in the interim, the client will be expected to handle those on his or her own. And the notion really sitting behind unbundled legal services or limited scope engagements is, as Stephanie sort of suggested, that we're able to provide legal services at a lower cost, in part by shifting some of the responsibility for the delivery of those services to the lawyer, to the client himself or herself. And so really that has been seen as the great opportunity of limited scope engagements or unbundled services. When you deal with them though in my world where you start to ask what the risks are, there are three groups of risks that have been identified. The first is a risk of disagreement between the lawyer and client related to what work the lawyer will do and how much the lawyer will charge for that work. And in fact, I have received a call today from someone who I know right now there's a lawyer that I used to work with and a client of theirs who are arguing over what is covered by the engagement, what is not covered by the engagement. And the interesting thing the Missouri rule does, the Missouri rule actually contains in its comment a sample engagement agreement for limited scope engagements that literally has a checklist. And the lawyer and the client are expected to sit down and go through the checklist and say, I will do these things, I will not do those things, and check off what they're going to do. And frankly, I think to that degree works pretty well, although I think it really has to be coupled with good informed consent, which the lawyer has to often work very hard to establish. The second group of issues relate to how is this relationship received in the outside world? And usually we see two groups of potential issues or problems there. The first is that someone, usually a court, may believe that the lawyer has taken on the entire engagement. So for example, if we take that example I gave at the outset, we say the lawyer is going to handle certain things but not handle discovery. If there are problems with discovery, how is the lawyer going to avoid being held accountable for those problems when the lawyer and client have agreed that only the client will deal with those issues? And the Missouri rule does attempt to provide some guidance there about a lawyer can file a limited entry of appearance and specify what they're going to do and not do. The second concern here with these third-party issues is what are opposing counsel going to think? And again, the Missouri rule tries to deal with that by saying if you do file a limited scope engagement, no entry of appearance, the opposing counsel is allowed to deal directly with your client on things that are not subject to the scope of the engagement. So for example, if my opposing counsel had a concern regarding how my client was dealing with discovery issues, they can call that person directly and know that they didn't have to worry about Rule 4.2, which is the anti-contact rule. The last group of problems, which frankly I think are the most serious ones that I don't think have been very well addressed, relate to those unidentified or perhaps undiscussed legal challenges. The client may have come to me and said, will you handle my personal injury case? What I didn't realize was that the person may also have a workers' compensation case, but because I'm not going through the thorough investigation with them, I may not realize those opportunities present themselves. Or they may have other claims, or they may have tax implications or medical lien implications that because I'm not dealing with the entire picture, I may not know. And that's one group of concerns, frankly, that I've seen lawyers get caught on in malpractice cases. They say you advised me as to my workers' comp case, but you failed to tell me my statute of limitations was running on a potential medical malpractice claim. And we also continue to see this as a real point of contention where clients will often come back and say, why didn't you tell me this? And the lawyer's response of, you didn't hire me to tell you that, usually doesn't play very well with the client. So I think that's one area where we're still really trying to deal with some potential problems.
Well, Stephanie, on that, back to you, because you've mentioned both in terms of the virtual law practice that you've established, as well as your interest in, increasing access, that you've had a great deal of experience with this unbundled world. How do you make it work for you, and how do you make it work for your clients?
I think that education is a key component when you're unbundling legal services. And I mean by that, educating the client. So maybe the client doesn't know the difference between full service representation versus limited scope representation. So I think there are ways to minimize the risk through a really well drafted limited scope engagement agreement. Checklists, making it clear what their responsibility is and what you're going to be covering. Doing really thorough client intake, and I have an online client intake process, but making sure you identify the collateral issues in that initial intake so that you can make sure when you're defining the scope of the representation that you're identifying any of those potential issues that may be out there and clarifying what you'll be handling. But I think too, explaining to the client maybe in handouts with a limited scope agreement, in a traditional divorce, full service representation in person, this is what you get, versus this is what you'll get with me, and these will be your responsibilities. So when I think of unbundling, I think of you're doing a lot of educating and hand-holding of that client in order to protect yourself.
One of the things that was interesting out of the ABA Standing Committee on the Delivery of Legal Services last year was a Harris poll that was conducted talking about how people find lawyers, not only what access, what services are they getting, but actually how they find them. And some of those findings were really quite interesting. Apparently fewer than 20% were very or somewhat likely to consult Facebook, although apparently we've had Facebook postings going on as this conference has been undertaken. 15% consult blogs, 9% look at Twitter. I don't know whether we've had any tweets going in or out as we're going this morning. I look forward to, I may or may not read them later on. But apparently 49% were very or somewhat likely to consult websites where consumers can post legal questions for lawyers to answer. And 47% were very or somewhat likely to look at lawyers' ratings websites. Oh boy. And 44% to check a lawyer's own website. So, Stephanie, back to you first, and then I'm going to turn to Dave on this. In terms of how your consumers are actually coming to you, what advantages have you found, or disadvantages have you found by setting yourself out as a virtual law practice?
Well, in terms of advantages, I think people are going online, and even if they're consulting with review sites or friends and family, they're still going online to consult with their friends and family to find out about the attorneys. And so my website is my front door. So these consumers that are going online and Googling for services, they're able to come to me a lot faster online. It's a fine line to walk, though, because I'm an attorney 24/7. So when I'm engaging in any social media or networking, I have to be careful to make sure to keep the professional and personal separate. And there's a lot of ethics risk in that. But I find that my client will use rating sites to contact me, to come to my website. So that's kind of how I've developed an online client base, is through the social media methods.
And Mike, you're in a more traditional practice setting with Hinshaw. What do you find in terms of your clients and a web presence, or what you're seeing in terms of the law firms and lawyers that you're advising, in terms of the way in which clients are accessing their services and problems that are arising as a result?
Well, I think for the firms that are more focused on serving corporations or corporate entities, frankly, there's a desire to avoid, the numbers say one thing, but the dollars say another. And for the larger law firms, there's a lot of traditional means that are still being used. There certainly has been an increase, though, for example, in online RFPs where people are required to submit all of their materials online. They're often vetted online. There's often meetings like this where you talk with people online. The other place, frankly, where we're seeing a real transformation in thought is how do law firms set up their websites to really try to address the needs of their potential clients. And that is something where certainly we've seen, for example, the increase of video usage, sound clips, and those types of things, even in some very large, frankly, rather conservative corporate firms. And I do think that that's someplace where we'll continue to see a move over. The older generation of partners will certainly say that it's personal relationships and being involved in the same civic organizations, et cetera. But we're really seeing a change for the younger lawyers and their clients in being more aggressive in using the internet as a platform to develop clients and communicate with clients. And certainly, one of the big things we've seen a real increase in blogs. I don't know of any law firms, any corporate type law firms, that would say they've been successful with Twit. I'm sorry. Here's Twit. I have Dave Bilinsky, one of the more loyal tweeters that I've seen. But frankly, for the corporate firms, I think they feel like the 140 characters really doesn't do a whole lot for them. And so where you are seeing it used typically is more in a marketing capacity. And the marketers are basically sending out an announcement to a new partner or some other development. There's really not a lot of ongoing activity there.
One of the interesting things coming out of a February 2011 newsletter from the New South Wales Legal Services Commissioner was a reference to the Twitter feed at The Legal Oracle, which was the first Twitter law firm in the world to offer free legal advice in 140 characters or less on questions that have been tweeted. So, Dave, where are we flying to at this point? And tell us about how you come to this and what you're seeing as a regulator, as a practice advisor, and somebody who's actually going from Shanghai to Argentina to talk about these issues.
Well, that's a good question. I'm going to try not to wear my regulator hat because, quite frankly, I'm very interested in the whole growth of Twitter and Facebook and blogs and how lawyers are really jumping on it. And I've seen new lawyers particularly benefit from the combination of blogs and Twitter. There's one in particular that I always talk about. Her blog is Human Rights in the Workplace. Her name is Donna Seal. She's a mom that lives in a small town, Manitoba, with 2 kids and practices out of her home. But courtesy of Twitter and her blog, she's built a totally national reputation in her area of practice and is quoted in national publications all the time. So if you're newly established in practice and wish to establish a niche practice in a certain area, I think there's probably no better way than to start writing in your blog, writing in other blogs if you can, and start tweeting and start developing followers. And I think properly done, the marketing rules allow that. I blanch when I start seeing people answering legal questions by Twitter, and I know there's at least one lawyer that has done that, and I don't know how you can get legal advice into 140 characters, but I leave that for him. Don't do it, yeah.
I think it's don't do it, very risky, call me, good hourly rate.
Yeah, exactly.
I think that fits. Just someone check me on that, I'm not sure.
In response to what Michael said about bigger law firms and blogs and that sort of thing, we have one law firm out in Vancouver, Davis & Company, which is a large law firm, and they went out on a limb, and one of their younger lawyers developed a blog on gaming law. Now, the development of video games out in Vancouver is a particularly hot market. We've got a lot of developers there, and he saw an opportunity. So he built a blog that specifically addressed the gaming industry. Went so far as to go on to Second Life and establish a law firm on Second Life. So there are lots of opportunities to go out there and market yourself using these new technologies. And I think, again, so long as you're mindful of the marketing rules, they can be done so.
I have problems managing one reality, never mind a virtual one, but leaving that aside,
Wow.
I think one of the things that comes out in terms of the power of technology, as well as the way in which consumers are encountering, accessing, and expecting the delivery of legal services is through the internet, through unbundling, through self-help. And in that respect, at least, what LegalZoom is doing is, in many respects, changing the game. So, Chas, why don't you tell us about what the proposition is, what you're running into, where you see the market going?
Sure. So I've been with LegalZoom not from its from its inception, but just a little under 8 years. We just celebrated our 10th year offering our services to the public last month, and I've seen this company grow from, I think there was 35 or 40 people when I joined it in 2003, and we have over 500 employees now in Los Angeles and in Austin, Texas, where we opened an office in Austin last year, and I think we have 150 people there within a year. And we're seeing the idea that before LegalZoom, there's always been the concept of self-help. It existed in Nolo Press, which was started out of, I think, Berkeley, California, by Jake Warner in the 70s. They used to have sharks with little ties on their, on their books that said, no sharks, come and use us. Before then, I think we were even looking toward the 1700s. There are books called Every Man His Lawyer that had little forms on how to convey land, in the United Kingdom and in America. So the concept of doing it yourself hasn't really been anything that I consider new. However, I think the technology of how people do it themselves is something that we are seeing a lot of different and interesting innovations coming out. And I think what you take a look at what Paul's doing and what the ABA is doing with its 2020 Ethics Commission is they're taking a look and saying, well, wait a minute, all these what they call non-lawyers are able to innovate. They're able to offer these services, but we kind of can't. And Mike's talked about some of the ethical boundaries that you can get up against with respect to offering things, online or virtually, as is Stephanie. And I think they're really trying to how can we really level that playing field? But what I'm seeing is, as in my position as a vice president there and as the general counsel, is a starvation of legal knowledge. And people out there want that information. And up until the self-help or the way it's been done, it's usually been do it on your own and run the risks, or come to me, who I'm, the lawyer, and give me your facts. I will ask you some questions, and then I will tell you what your problem is. I will tell you how to solve it, and then later on I will also tell you how much it will cost. The problem is that there hasn't been a lot of the middle. And you look at other industries, whether it's in medicine or in tax, even engineering, that's changed. Nurse practitioners and radiologists and the person who takes your blood pressure, the technician, they perform a lot of the very kind of commoditized medical services. And for instance, TurboTax has, taken a big chunk of the tax prep market, not from people who are going to accountants, but typically from people who are doing it on their own and screwing it up. And LegalZoom is really looking to take advantage of, and has, I think, taken advantage of the fact that there was a void in the marketplace for middle America, people who I think are average demographic, depending on product, is anywhere from $40,000 to $75,000 household income, and trying to fill that need that is between what I think the professor said was those that can qualify for legal aid and those who can afford. Whether it's, I think the last average from Altman Weil was like $229 or $265 an hour is the average kind of lawyerly rate. And I think that right now we've come to this kind of apex where LegalZoom has done a lot and done almost all that it can really do within the confines of being a non-lawyer. And the next frontier is going to be combining legal advice with the marketing power of a brand like LegalZoom and the innovation and technology that are underneath it and kind of are the foundation of it together to serve and even more expand that access.
Stephanie, let me go back to you though, because as somebody who's working in the online world is responding to client needs and client demand with knowledge of general practitioner, solo or small firm practice community, I mean, something like LegalZoom sits out there as a directly competitive threat. And in that respect, at least, how do you think lawyers either ought to respond or are responding to what Chas has identified as at least a market opening or a market need?
Well, I think that there's enough space for both to coexist. I think there's a need for both types of services. What Chas is talking about, I've written it up. We call it the branded network concept for a company. Rocket Lawyer's another one, where they're trying to combine the document assembly and automation technologies with the actual licensed attorneys. So maybe the solos and small firms, to stay competitive, need to join a branded network like this, where they can reach out to this prospective online client, but then also cultivate their own client base for maybe more of a unique niche practice area to deliver more personalized services. So I'm kind of, in the future, if I had a crystal ball, I see sort of a hybrid of these types of services. There's definitely a need for all these alternatives in the legal market space. So I see solos and small firms adapting, working with the branded network concepts, but also creating a brand and reputation for themselves and cultivating their own online client base too, kind of a combination.
But one of the issues that then ends up coming up, where people have talked in the legal profession, in ethics circles as well, is this whole concern about a loss of professionalism when what you merely sort of reduce everything to is a kind of commodification or commoditization of services. Renee quoted from Richard Susskind earlier on, talking about the ways in which bespoke services or tailored, highly tailored services for individual clients aren't only now responding to a part of the market, and you've got the commoditization, high volume, repeat types of work that are being done with economies of scale. What gets lost in terms of the professionalism, or what are the ethics risks if we head in that direction? Stephanie, I'll start with you and then go to Mike.
What are the ethics risks?
What are the ethics risks if we end up sort of saying, okay, law is just another commodity?
Well, then it's not a profession. On a case-by-case basis, we have to analyze our client's needs and decide whether it's appropriate to be unbundled or appropriate to be handled online.
Mike, if you're future casting in that respect, I mean, and you're deeply involved in some of this, both with the ABA and in Missouri, how is the bar responding? How are regulators responding to this kind of change in direction?
Well, I think the first thing I'd say, frankly, is that I think the regulators are really struggling with it. I actually think, I want to answer your question in a slightly different way by talking about two different groups of things. The first is, I think that the sad, cold reality out there right now is that for an awful lot of sole practitioners, it is a struggle to have a good practice that makes you happy, where you really feel that you have the time, the ability to serve clients and to do well by them. And I actually think that part of the evolution should be looked at by the lawyers as an opportunity to actually make their life better. And I think that hopefully there's been some resistance, and I think that some of it is lawyers are always resistant to change. We are a precedent-driven group. But at the same time, when I meet with a lot of lawyers, there's a lot of struggles out there. But I think the other thing that sort of to reflect more directly on your question is that the key component of the professional relationship for lawyers is really twofold. The first is the notion that we have a fiduciary relationship with our clients. And I think one of the real concerns that has been raised by the ABA in discussing should we have screening rules and things like how we're going to handle unbundled services and those types of things, there's a real desire to make sure that the client's interests are still really being preserved, and that it doesn't simply become an issue where the whole goal of the legal profession is to see how much money we can make in getting people into legal boxes that they have to pay us to get out of. And I think that's something we'd like to steer clear of. The other thing certainly about the profession is that there is this notion of a higher calling. It's a society that lawyers aren't part of a democratic society, and we need to work to protect that, which I don't think lawyers have always done well. There's also the obligations we have in the court. And frankly, there are the obligations to society at large, things like pro bono. And I think one of the concerns that people have is that we move too much to a consumer-focused, monetized practice, that in fact, in addition to, as I think Chas said very accurately, and Stephanie said, there's a vast space that wasn't being well served by the legal profession between those that were qualified for pro bono legal services and those that could afford corporate legal services or firm legal services. And I think that now there's a desire to try to fill that void. And I think there's a concern that in filling that void, we may then ultimately pull the resources away from those who need indigent services or need pro bono or other supported services. And there's a concern that those may go by the wayside.
There are a number of different innovations that are resulting from these developments in technology. And I want to switch gears slightly to that. We've talked about the unbundling of services, some of the services that are available online for people to access. And one of the areas that's a bit new is online dispute resolution. And Dave, I wanted to go to you on this because you've had very direct experience in this work. What's ODR all about?
Okay, to really go into this, it's going to be my thesis that the court system as we know it now is the equivalent of a dead horse. And the old philosophy is if you're riding a dead horse, you flog it harder in the expectation that somehow it's going to make a difference. In my view, the court system, for precisely the type of people that Chas and Stephanie have been talking about, the vast majority of people who are not perhaps of the upper class are not being well served by the current court system. It's simply too expensive and too long for them to effectively get any kind of legal remedies. As a result, there's been the growth of something called online dispute resolution, which is really, at its simplest form, the application of computer technologies or communication technologies, primarily computer technologies, to the resolution of disputes. I contrast this by looking at the court system. The court system, if you look at its framework, it's synchronous. All parties have to be in the same place at the same time. It's geographically tied. All parties have to come together in one location at the same time. And it's serial. In other words, one case proceeds after another after another. Those are structural foundations around the way the courts work. And I submit that those are preventing the economic and efficient resolution of disputes. Contrast that with ODR. ODR is accessible over the internet. It can be asynchronous, which means Paul and I do not have to be at the same end of the same internet connection at the same time to resolve our disputes. There are techniques that allow him to post and then for me to come in at a later time, read his post, or read the administrator's post, the person that's doing the in-between work, and then I can respond in time. It's parallel because many cases can take place at the same time. It's not one after another. It's geographically independent. In other words, Paul and I do not have to come to the same location at the same point in time to have our discussion to resolve our disputes. We can be in completely different parts of the world. And it's time independent as well. We can do it whenever we want. In the ODR process, it's really the application of what is called game theory, and I'm an old mathematician before I came to law. It's really the application of game theory, and if you remember the movie A Beautiful Mind with Russell Crowe, that was about the invention of game theory. So what this is in my view, an end run around the court system so that people can resolve their disputes without going to the high price cost of trying to resolve disputes in the court system. And then you're looking at ways around that, like, a pro bono and all the rest of that. In my view, this offers much more promise to resolve disputes than the attempts at trying to, as I say it, flog a dead horse.
That's a neat transition in terms of, here's something that technology is permitting, and yet there are still concerns about, as we've all heard throughout, access to justice, and particularly for those who would otherwise not even make it into the middle class. We've talked about a significant portion of society that would have unmet legal needs and can't or won't access legal services. But you have legal aid, in various shapes and forms across the country, understaffed, overworked, underpaid. How can technology end up actually enhancing access? Because there's lots of restrictions on technology, and we'll get back to some of the ethical issues. But if we're looking in particular at that segment of the population and at legal aid offices as they're currently constructed, what might we do differently? Chas, have you thought about that?
Yeah, a little bit, and I think we just had. I just lost it. Maybe Stephanie can help me out. We just had the American Bar Association just gave the Keene Award for access to a San Diego company who is a legal aid company for doing for basically providing legal aid online or having a technology aspect to it, and it's, I think it's the same award that Stephanie had won before. Do you remember the name of them, Stephanie?
It's a Keene Award.
Yeah.
The company's name is Legal Genie.
Legal Genie, I knew it was something like that. Yeah, and you see that stuff happening. I personally have been in my role at LegalZoom, I've been in contact with Mark O'Brien, who heads up a nonprofit called probono.net and their subsidiary Law Help Interactive. And Law Help Interactive is really designed, and they're funded to take technology, go into courts, go into these areas, and try and automate some of the forms that people are using every day. And you see this happening kind of, I hate to say it, but it is happening kind of piecemeal. The state of California has it, and they've automated a lot of forms. I personally, as someone who deals with consumers every day, I don't believe they're very consumer friendly the way that they've automated or allowed those forms to be done. But I think that you're at least seeing someone try and move. At the same time, I believe that without looking from the consumer toward automation and instead looking from law into automation, I feel like you're getting a disconnect with the consumer. And one thing we know is that individuals who are looking have a legal need that they need help with right now, whether it's a paternity issue or an eviction. The last thing you really want to do is kind of slog through a lot of legal jargon They want to be told, here's the way it will probably work for you. And here, if you answer these questions, we can get you either to a lawyer or get you the form you need to get it filed with the court to stop that eviction or to, to answer that complaint.
Mike, you identified providing pro bono services and service to the community as one of the core elements of professionalism in this regard, and Chas is identifying at least one area where the merging of technology with increased access to justice might work. What do you see firms or lawyers that you're working with doing in this regard, or what do you think is next? And is it an area of real growth, or is there still some resistance to change?
I think when you talk about lawyers, you're always talking about resistance to change. In the materials that I supply, I put a curve in there that's the acceptance of technology. And when I show it, I like to joke that if you look, you'll see there's, I think, 3 or 4% early adapters, and then you have groups after that. When you talk about the legal profession, it's all shifted to the back of the curve. Most lawyers, and for example, marketers will often say, obviously marketing, you want to have a new theme or a new message. In the legal profession, the first question you always get asked by a partner committee is, who's done this before and what was their success, which of course then takes away the innovation. Right. And it's amazing how frequently lawyers struggle to be even slightly innovative. The nice thing that we are seeing, and I think Stephanie and things like the legal rebels are sort of an indication of this, that there are pockets that are going off and doing some of these things. And I think, really to emphasize what Chas said, I think there are a lot of opportunities for greater technological interface. And I think part of what has to happen is there has to be a notion of what's always been done doesn't necessarily have to be done. Around here, I just had a colleague that finished the Missouri Appellate Court brief. And if you look at Missouri Appellate Court briefs, you'll find a phenomenal percentage of them are struck because people don't do the points relied on properly, which basically is this arcane intonation of exactly what the error was. If somebody's preparing their own appellate brief, they're probably going to mess it up. Frankly, many lawyers mess them up. But does it really matter that much if someone's able to clearly identify, this is the order I'm appealing from, and this is the problem I have with it? And I think that we're having to see that sort of thing happen. And I think the other thing, frankly, is that a lot of the courts are recognizing these things. I think Dave Bilinsky was there. There's a great center for technology in the courts in Williamsburg, Virginia, where they really are trying to provide answers to a lot of these questions, even questions like, how do we have people with hearing impairments on the jury? How do we have people with visual impairments in the jury? And it's amazing to realize that our society today provides all of those tools. And I think things like online dispute resolution. Why not have a jury trial where the jurors are able to watch it through Skype, as we're doing today? Do we really need to have people present? And when you start to look at this, you'll realize that, for example, they've done international appellate arguments where they have lawyers that are scattered all over the world and participating through video conferencing. And there's no reason not to do that. I clerked for a federal judge, and it was fun to travel with them. But the reality is to have people fly to St. Paul, Minnesota to argue cases in December is not a brilliant act. It's not necessary.
As a Canadian, I think the winter trip to Minnesota should be on everybody's agenda.
That's where you summer, right?
Yeah. Compared to Saskatoon, it's balmy. But it raises another interesting question in terms of adoption. And Stephanie, I want to go back to you first and then to Dave in terms of the adoption both by lawyers and by consumers of the virtual law office concept. You've introduced it. Maybe you can talk about the different models of virtual law office and what you've encountered with clients who you're meeting for the first time by Skype. What does that do in terms of changing the way you've practiced?
Okay. Well, we're really seeing 2 primary forms of virtual offices that attorneys are adopting. And the first one is like my own. It's completely web-based. So, I work from home or wherever I feel like as long as I have internet access, but I don't meet with them in person. And then the other model we're seeing more of attorneys set up are a traditional law practice. And I think Dave put up some slides there of some case studies you might want to look at. But I think one of the first ones is Rice Family Law. It's a traditional family law firm, been around 25, 30 years, and he's litigation. It's a litigation-based family law practice. But he's cultivated an online client base. He serves the military stationed overseas who need secure access to family law matters. And then he also, for his in-person clients, will use the virtual office for the intake, online payments, letting them review their documents, a number of different online features. So I think we're going to see a lot more of these sort of hybrid, traditional with a virtual component, probably more of those than this type of practice I have, which is completely web-based. But in terms of client adoption, when I first started doing this, it seemed like they wanted to see me, make sure I was human, especially my older clients, or the older generation. They'll go to me online, find me online, and then want to talk to me in person, make sure I'm human, and then they'll go right back online for the rest of the process. More and more I've noticed that they have access to webcams and want to do more of the web conferencing. That my clients who are between the ages of 30 and 40, which is the bulk of my client base, they are comfortable communicating completely online, text-based communication. So that's what I'm seeing. And I do a lot of pro bono work online. And those clients don't seem to have a problem with accessing the technology. If they don't have internet access, then they have a friend or someone that has internet access, or they go to the public library. So in terms of getting hold of the technology, it doesn't seem to be an issue there. I don't know if you want to go through a couple of the other slides or not. I just have a couple of different models.
Sure. Why don't we head through those? I think one of them is the Texas.
Yeah, and this is interesting because Ronnie Combs actually lives in North Carolina, but she has a virtual law office that serves Texas law. So
There we go.
So it's interesting because I get a lot of attorneys who contact me where their spouse is stationed in the military, and they need to move around, and they don't want to have to take the bar everywhere they have to move. So, gives us the flexibility to be able to practice law where they want to and work with their clients. So that's another model, and then I have a screenshot of my own practice, and I do unbundled again. The one after that is Downey Noble and Seat, and they focus more on, it's again a traditional practice, so they meet their clients in person, but then they also use the document automation and assembly tools to deliver those forms online. I think what we're going to see a lot more of too are these law firms that are adding like web calculators or maybe even free online forms to the prospective clients and the public as a way to draw them in, and then converting those prospective clients using those web-based tools into either full-service clients that come in person or to online clients. I think that's sort of the way it's going.
And Paul, if I may, just a
Go
quick
ahead.
comment. Stephanie mentioned the lawyers who are, for example, they have a practice in Texas, but they're actually residing in North Carolina. Many legal ethics people would say that if your office is actually located in North Carolina, at least under the current interpretation of the rules, in particular ABA Model Rule 5.5, you actually do need to be licensed in North Carolina, even if in fact all of your clients are in Texas. And I know your state of California, or the beer bar case, is sort of one of the cases that's used as a window into that. I think this is something where, when we talk about what's changing, what will technology do, I think it would have been hard for a lawyer to have operated a Texas practice from North Carolina with just a telephone. And the internet is making this possible, and I think we'll continue to see a push. And when you talk about where are we going, there are certainly some people who believe that we will end up with much more of a unified bar in some way, shape, or form. Some of it because of what's gone on in Europe with the European Union now. A person who is admitted in, not Yugoslavia, in Germany can move to Spain or move to England and become a lawyer licensed there very quickly, more easily than a lawyer can move from Missouri to Washington State and do the same. And I think we'll see pressure there, but I think we'll also see pressure from these types of online services.
One comment on that, and actually we've had reference made earlier this morning, both by Jillian, to a national licensing type of approach which is being talked about, as well as this issue of multi-jurisdictional practice. In addition to the ABA issues paper on alternative business structures that was released this week, the ABA also released its issues paper on multi-jurisdictional practice, and you'll see in that issues paper discussion, and I'm serious, this is not a plot, a long discussion of the National Mobility Agreement in Canada, which is actually used as an illustration of a kind of 100-day passport, if you will, into another Canadian province. If you're based in Ontario and you want to practice for up to 100 days in British Columbia, you don't even have to let the regulator know that you're there. There are other certain requirements, one of which is actually that you cannot establish what's called an economic nexus with the province, and there's a specific definition around it. But with the European model, with the Canadian model, with the Australians looking at increased harmonization, this is something that's actually explored in the issues paper, and then I think you'll see the Ethics 2020 Commission taking a closer look at. But Dave, you wanted to leap in on these issues.
Well, I just wanted to say, since I seem to be wearing the regulator's hat here, that I wanted to offer an apology to everybody for the fact that I'm terribly aware that what is accepted wisdom today were heresies yesterday. Yeah. And really that's what we're speaking about, our heresies. We're turning the profession over on its ear. I know that the regulators perhaps have been a bit slow in terms of responding to the challenge of new technologies. I know there's the 2020 commission from the ABA, the Ethics Committee, that's actively looking into this. I'm a little dismayed that they gave themselves a 3-year window. I would have hoped that that would have been much faster. I know up our way we have the cloud computing working group that is looking at the whole implication of cloud computing on the practice of law and how can we continue to practice properly as lawyers, I guess is the framework, using the new technologies. But in terms of what Stephanie has talked about, the unbundled and going virtual, I can tell you that a lot of lawyers have been slow to adopt the virtual law practice due to the fear of being disciplined by the regulators if indeed they step out of line. And nobody knows where the line is right now, and that's part of the problem.
A couple of things on that front. One of the issues actually that confronted as part of the Canadian Bar Association's National Ethics Committee was this concern about what is it like to practice ethically with new technologies, or what's it like to market ethically with new technologies. And one of the things that we did in our examination was realize we didn't need more rules, that the rules themselves were adequate to cover the circumstances, but that what lawyers needed was that guidance. And so what the CBA did out of our committee, and we released over the last couple of years, sort of best practices types of approaches, frequently asked questions. How do you respond in terms of the rules, and how do the rules actually apply to these new situations? And one of the questions that's coming up now in the US debate that I'll put to all of the panelists right now is, do we need more rules? Do we need rules to govern these new situations very broadly, or is it just a question of adding some commentary, adapting the circumstances, or being a little more sensitive to where some of the old rules might not necessarily fit the new circumstances? Chas, let me start with you. I go for the big questions, and then we'll get to some of the specific issues, and I in particular want to come back to talking about cloud computing.
Well, you might not like to hear my answer, but I'm pretty sure that I'm gonna channel Professor Hadfield on this one. And as someone whose undergrad was in economics, I think in a market that's overwrought with rules, that more rules probably aren't going to do it any justice. I don't think more rules are going to increase access. I don't think more rules are going to drive down prices. I don't think more rules are going to make consumers happy with the legal system. That being said, I don't know how you get from where we are today to where we want to be in 10 years. For instance, even in the UK, what they're doing with alternative business structures, it's not that they have no rules, they just have the people who used to, judge and make rules for the legal profession. They're now, both lawyers and non-lawyers, making rules for these alternative business structures. So I don't think that there's no way in this country, or I think others, that you can provide legal services and have non-lawyers and lawyers work together, whether it's through marketing or through alternative business structures, without putting some sort of rulemaking onto the shareholders, the non-lawyers as well. And right now, the ABA, the model rules, they don't really make rules for non-lawyers. But if we're looking to integrate them, I feel like they're going to have to. At the same time, that chagrins me a little to think of what it would look like.
Mike, you spend a lot of time in your world actually advising people on the rules, and maybe as a business development tool, you'd like a few more.
I would say discipline, it just helps me. No, honestly, as you were asking the question also, I was thinking, to pull in another news story that may seem disconnected all the way, I feel like it's connection. The recent story of this lawyer, I believe his name is Michael Kruger, and his insider trading scam, he's been running for 17 years. I think we see another opportunity where the notion the federal regulators are going to sit by the sideline as people engage in insider trading seems hard to imagine. And the reality is, this was not an easy case to catch, and I'm sure that enough lawyers out there are reading the stories to figure out how to do it themselves. I do think we're going to see a more active federal regulator There's been some talk about having a federal regulator step in and really at least regulate the securities bar, the securities lawyers, and the lawyers that advise on transaction stuff. But I do think also, I know I'm directly involved, and I think there will be some minor tweaking done to the model rules. I'm not sure if they'll deal with necessarily with the multi-jurisdictional practice issue, but I know, for example, there's been some serious thought of, do we need to make some of the requirements that lawyers protect data in technological settings more clear in the rules? And frankly, one of the things we've sort of brushed upon, although then headed in a different direction, is the whole issue of disaggregation, which is the corporate version of unbundling. And are we going to use outsourcing? Are we going to use particular providers? And I think that is going to also be a second set of forces that are really pushing on things. I think the legal community really is at a critical moment of different pressures coming from consumers, from the technology, from the competitors, and from within the profession itself. And I think I think that the practice of law will be very different 20 years from now than it is now. And the only reason I say 20 years is because lawyers are so resistant to change. There will be some lawyers who will be changing the next year or two. There will be firms who will be changing the next 2 years. And it's funny, we talk about Stephanie's able to have her practice where she's very remote. I know an awful lot of large firm partners who have done very well and now decided that rather than spending their time in fair cities in Canada, would much rather spend their time on the beach in Florida. And with the computer, you can do it all now, and there's no reason not to. And there's certainly that push as well. And for some lawyers, it seems like it's a foreign concept or something that's not good. But it's not one group of people that want these changes. And just as a final comment, I think the biggest difference between the United States and the UK was that when the Solicitors Regulatory Agency, the SRA, went into this evaluation, one of the major things that they looked at was how to improve competition and consumer service.
Yeah.
And that is not something that has been looked at in the United States. And I think if we really did turn things back on their head and say, okay, if we're really fiduciaries and agents of our clients, how are we really going to serve our clients better? An awful lot of these walls would suddenly not make a lot of sense.
Stephanie, if I might to you, I mean, in terms of establishing a virtual law office and actually being an innovator, you took a considerable risk. The fear of discipline by regulatory authorities when anybody's doing anything new is prevalent, but in particular in this area. And do you find that either for yourself or colleagues who are looking at virtual law office practice that remains a concern, that Dave's identified? People are reluctant to take the risk because they're concerned about going outside the line isn't clearly defined, and they don't want to get whacked.
Well, I was kind of fortunate here in North Carolina, right as I opened my virtual office. An attorney had asked our ethics committee if it was okay to practice with a virtual office, and they gave it the okay. And since then, there have been other states, such as Pennsylvania, this past fall, that have given it the okay and kind of defined it a little bit better. So certain states have said it's okay. Other states like New Jersey has the bona fide office rule that puts place restrictions on a purely virtual law office. But I don't think that the ethics rules, it is appropriate to put in more ethics rules, because I'm advising the subcommittee here in North Carolina that's reviewing a proposed cloud computing opinion, which will directly affect virtual law practice. And any attorney using cloud computing, it's a broad proposed opinion. And I think the danger of trying to nail down the technology now and then not update the ethics opinion is really foolish. And so I've been trying to sway them to provide references or guidelines or best practices, like you mentioned, Dave, rather than put technical requirements into an ethics opinion. I kind of have some exciting news to share when we're talking about this. There's a group that's called ILSO, International Legal Technology Standards Organization. It's a non-profit that's been working closely under wraps for the past year. And on Sunday, right before Tech Show, they're going to be posting online this manual of standard technology, suggestions for technology for the legal profession, so that the state bars and other regulatory entities can say, okay, here's a standard. I mean, because we've got all these multi-jurisdictional practices that people want to establish, it really can't be state by state if a multi-jurisdictional firm is going to have to comply with 3 different state bars rules on tech that are completely different. It's just not practical. So these standards, this manual is going to be open for public review and feedback. Some of the folks that helped create it, did a malpractice insurance carrier advising, an ethics law professor, some SaaS vendors, IT programmers. So really a wide variety of folks within these different committees, subcommittees that pull together this manual. I think it's quite an undertaking, and their goal is just to get it out there so that attorneys have these guidelines, but that it's standardized. So people should watch out for that. I think they're going to try and get it out Sunday night. Hopefully it'll be used by the state bars.
Very exciting news. You heard it here first. I trust that a tweet has already gone out. One of the things that all of you have touched on, and actually, I mean, there are a whole variety of ethical issues, but all of you have touched on, and actually the ABA's issues paper on client confidentiality and lawyers' use of technology issued last September gets into some detail discussing, is this whole question of cloud computing. And I wanted to spend a few moments actually talking about what cloud computing is, how you use it, what some of the risks are. And the paper itself goes through and gives a few sets of examples in terms of what cloud computing is, but there's not really a kind of hard definition of what it means to be in the cloud. If you've seen the Microsoft advertisements, there are things like online data storage, internet-based email, software as a service, law practice management applications, sort of that you exist virtually in that respect. And they suggest that there are a whole series of issues. There are a number of bullet points that come through. Unauthorized, as ethics concerns, unauthorized access to confidential client information, storage of information on servers in countries with fewer legal protections, a vendor's failure to back up data adequately, unclear policies regarding ownership of stored data, policies for notifying consumers of security breaches. You all got the emails this week as well, if you're a member of any kind of hotel or airline or other chain, about an email breach in that respect, insufficient data encryption. You read this laundry list of things, and if you're like me, you get very afraid and you want to go back to your cave and just sort of not encounter the world. But in dealing with cloud computing in particular, it seems essential to a virtual practice, and yet we're not altogether certain that we know how to address some of these concerns. Stephanie, let me go back to you in terms of what you might recommend for others or how you might encounter the cloud. First off, how do people use it?
How do people use it?
How do people use it in terms of a virtual law practice?
I think actually most law firms these days of any size and shape are using cloud computing, and I think they may not even realize it. Take a firm that just uses Lexis or Westlaw for research, and they're storing the history of their research for a client case online. Okay, that's software as a service. That's cloud computing. Web-based email. Most firms are using some type of email system that's going into the cloud. So I think it affects everybody. It's not just the virtual law practice that uses cloud computing these days. I think that train has long since left. But I think that there are ways to minimize the risks that you talk about, ways to do it responsibly by, really vetting out the technology provider, reviewing the service level agreement. With any practice management tool, whether it's in-house, installed in-house, or it's on the cloud, there's some risk involved in it. I think that there are just definitely ways that you can minimize it.
Yeah, it's interesting to me because I look at this, the idea, and I'm 100% aligned with Stephanie on the idea of using the cloud. I think that cloud computing is an innovative technology that allows smaller law firms that may be less profitable to take and make access of a virtual law office without purchasing data storage and servers and things that they would need to house that data on site. But I do believe that you can do this safely. There's a difference between safe and perfect safety, right? Safe is having safeguards in place that most people would find reasonable, but it doesn't mean that they're impenetrable. Epsilon, that you just mentioned, which is one of the largest email marketing companies on the planet that has thousands, millions, hundreds of millions of points of data, and has some of the best security, still was able to have some of what they do penetrated. And I think the interesting thing is you're talking about, in this case it was just credit card numbers, but in the cloud there are social security numbers, there's bank information, account numbers, there's a lot of that stuff in the cloud today. And the fact that maybe someone's will or a stored version of a living will might be might be worse if it was found out or discovered by a hacker is a little absurd. Now, that being said, some clients, the profession of guilt in a capital murder case, that is something that might be a little scary if it did get out and was found by other people. And we'd have to figure out if a third party had data that showed a criminal defendant's guilt while a case was still pending. Well, what would you do with that? And that to me is the kind of the $1 million question about cloud computing. Maybe ask more questions than it answers, though.
Mike?
I was actually going to pull this, the author of a book. If everybody wants their skin to crawl on technology and security in general, there's a book that frankly is an interesting read called Cyber War that actually gets into technology issues and protection of data. But one thing I was going to say is an awful lot of these same lawyers who are running around fretting over what is the data protection of Microsoft's online data storage are the same people who put their briefcases down and don't think about where they put them.
That's right.
And are also the same people who have loud, privileged phone conversations on trains while they're airplane takeoff. And it's amazing. It's amazing to me the double standard that we often have when we approach technology and security. My sense of things is that, as Stephanie talked about vetting the vendor, if you pick good vendors and you look at their agreements and make sure securities are in place, they will actually probably do a better job than most small, medium-sized firms in protecting the information there. The only other thing to add, though, is the lawyer also is, and I think this really picks up on what Chas said, the lawyer has to recognize that there are some things you never want to put anywhere near the net. And I'm not sure if it was ever included in it. I can't remember if I submitted it or not. There's a kind of a fun article I wrote for the National Law Journal called Serious About Confidentiality. And it starts off with a discussion of this hypothetical lawyer, Alice, who comes into her office. She has to use data cards to get in. She has 2 computer systems, one of which is connected to the internet, one of which is not. And then it goes on to say that this actually is not a lawyer, but rather it's a friend of mine who works at a defense contractor. And the defense contractors really do understand that if you want to keep stuff protected, you keep it away from the internet. And I don't think lawyers have really even started to think that data is not, we seem to believe that data is uniform and deserves uniform protections. The reality, as Chas mentioned, is that data has different values. And some of it may be stuff where we say, you know what, for this particular information, no, you don't carry it when you travel overseas. And no, you don't have it on a computer that you're going to use to hook into the local network at Starbucks. And no, you don't put it on a flash drive. And it's amazing how often lawyers will have incredibly important information where they really, frankly, do very little protecting, whether it's in paper form or in electronic form. And even things like, when you print off confidential information with client social security numbers, is that printer secured at all? Do you pick those up at night, or do you leave them there so the cleaning service can get them?
Right.
Those types of things. And frankly, we've seen breaches through all those methods.
There are 2 additional things I'm going to add before going to Dave on this, and one is actually as a cross-border matter with dealing with the Department of Homeland Security coming in and out of the United States, the right and the entitlement to actually take a look at what's on your laptop. And so you've actually had some guidance, again, from the Canadian Bar Association on what Canadian lawyers ought to do. And basically it ends up consisting of do a data dump back to your home server, cross the border with a scrubbed laptop, then when you log in somewhere in the United States, get everything back on. Just make sure you're not carrying it physically across the border because they're not going to be able to examine it in that regard. So that's one dimension that's actually changing in terms of security risks and breaches that lawyers hadn't necessarily thought about until a few of them were examined in this respect. The other is the illustration that people often give, concerns about electronic storage of material. If you think of what happened to law firms in New Orleans around Hurricane Katrina, physical storage wasn't that great either.
No.
And so in that respect, at least, I think looking at confidentiality and security of client information and documents, whether or not it's in physical or electronic form, we all have a lot to be concerned about. Dave?
I seem to be the apologist for the regulators out there, but I just wanted to bring a slightly different point of view to the table. And it's not that the regulators are trying to stand in the way of cloud computing. They have some, in my view, legitimate interests that they have to protect. Of course, the regulators out there are not supposed to act on behalf of lawyers. They're really supposed to protect the public interest. If they fail to do so, there is the distinct loss, a possibility of the loss of self-regulation. And I can tell you that the regulators are running scared on that issue. And that is probably why they're a little bit more conservative with regards to the adoption of new technologies such as cloud computing and all the rest of that. Now, I can tell you that their fears are well grounded in certain respects. If you're from Canada or if you're from the EU, the concern about privacy legislation governing you in your jurisdiction and how that could be broken if you allow data, for example, to be stored in the US and subject to the Patriot Act is a real concern. Technically, you could be breaking the law. And that's something that lawyers don't really like to be seen to be doing. I also think that cloud providers could be doing a whole lot more with regards to the protection of the data and the security that people feel, regulators would feel, if lawyers place their data in the cloud. Now, for example, not long ago, Intuit had a cloud service that was out there. I believe it was called Mint. What they did is they decided that they weren't making it. It was a free service, and they decided they weren't going to support it any longer. So they gave the people who used it, it's a financial program, a month's notice that they had to retrieve their data from Mint or it would be securely deleted. The only problem with it is that there was no upgrade path to take your data in a CVS form from Mint and move it into any other program. Now, if you're a legal regulator and you're looking at somebody using a legal accounting cloud program and that provider was to go out of business, the law firm is really in jeopardy in terms of being able to continue to protect the public interest and carry on in business. So there are some legitimate concerns about the viability of the cloud provider, how the continuity of the data, how are you allowed to carry on in practice? That's the Katrina effect. If it gets wiped out, how do you carry on business tomorrow? And I can also tell you there's a third big concern, and that is for all the cloud providers that are out there that are in the financial area. How does the regulator ensure that auditing standards are being met with regards, because if they walk in, they can get a forensic copy of your hard drive in your office today. That's not possible if it's on the cloud. Just by accessing the cloud, you alter the data on it. So from a regulator standpoint, if you're out there trying to catch a bad guy, and usually it's due to financial transactions, how do you secure the right evidence from the cloud provider that would allow you to prosecute that lawyer?
I wanted to leave a few minutes for some questions, and so we've covered a lot of ground, a lot of territory, but let me turn it to the audience and I'll channel the questions back for the benefit of our Skypers this morning. Any questions for any of the panelists about any of the issues that we've talked about? You're overwhelmed with technology, Garrett.
You talked about online dispute resolution. I just wondered who are the clients who are using the service, and what's the subject matter of these?
I'm glad you asked that question.
Let me just repeat the question. The question was, who are the clients using online dispute resolution services, and who's accessing?
Sure. There are a number of ODR systems in use in the world today. Australia, Mexico, Chile, and the European Union all have them. But perhaps the best example of an ODR system that's in use worldwide is the one that ICANN, the Internet Corporation for Assigned Names and Numbers, set up over the mediation of dispute names, your domain name registration resolution service. I can tell you that the UN is very, very interested in the whole area of online dispute resolution, to the point where UNCITRAL, the United Nations Commission on International Trade Law, has set up a working group to look at setting up an ODR system worldwide. Now, the reason for this is that when it comes to e-commerce, for the vast majority of e-commerce claims, you would have to go to the jurisdiction in which the vendor is located to effect redress if there was something wrong with the product or service that you've received. Well, if the product is $100, you're not going to go to Africa and sue them. And so e-commerce as a whole has plateaued around the world because there is a lack of a true resolution system to back up that e-commerce method. And that's why the UN is actively looking at this in a way to try and promote e-commerce worldwide by building what is in effect another legal system, a legal system for the internet.
Other questions, Mark?
As a follow-up to that, I've heard of like ODR being proposed for something like eBay, for example.
Yes.
They can get multi-jurisdictional, but in the United States at least, you have uniform commercial code, which is practiced in 49 out of 50 states. Is it something like the UCC or an international version thereof that could be used by this new platform?
Yeah, there's a whole issue around how do you adopt ODR internationally, because if you use the traditional method like treaties are hard to negotiate once they're in place. It's like they're set in stone, and so there's a whole analysis and area of thought around what is called soft law, and that is I actually have a slide here that shows this. If I that's not okay. Oh. Right here. It's a central clearinghouse that's being proposed. This is the Organization of American States proposal for ODR that's being taken up by the UN. All the sellers, as you can see there, opt in, and they put language in their contracts such that the method of resolving the dispute, if there is a problem between the vendor and seller, shall be ODR. So that solves the jurisdiction issue, the choice of law issue, and all the rest of that. And as a result, vendors and buyers would be comforted to use this kind of a system because there is a method in place because of the soft law adoption in the agreement of sale. Now, there's some controversy over whether it should be at the time of sale or later on at the time of dispute that the parties elect into that. And all that has to be worked out. But there is certainly some thought being given to all around that. And you're right, consumer standards are, what's type of consumer standards do you apply is another of the issues, consumer laws that you apply.
Other questions, comments? Sir.
Where do billable hours come in on this virtual law practice? And how are legal documents transported?
The question was how do billable hours come in on the virtual law practice, and how are legal documents transported? Stephanie, why don't I go to you first on that, and then Mike?
Okay, well, primarily, in my practice, I use fixed fee or value billing. So I have for the unbundled packages that I provide my clients, I give them a fixed fee. But with other clients, my small business, for example, I'll use a combination of billing methods. And I think this is what probably most virtual practices do. So I'll say for this scope, for these services, I will charge a fixed fee of X. And then for anything that exceeds that scope of what we've agreed upon, we'll be using my billable hour, and this is my billable hour. So that sort of protects me on those cases where I can't really clearly define the scope of the representation. But for the majority of the work that I do online, it is fixed fee.
Mike?
Did I answer the question?
Yeah, Mike, any comment? Oh, the second part of it was the transporting or transmission of legal documents that you're preparing and producing.
Oh, okay. I create the documents online, and a lot of virtual offices will use, complex document automation assembly programs, if you're familiar with HotDocs or Zari, to sort of streamline some of the more rote administrative aspects of creating legal documents, and then you tailor them to your client's needs. But for my clients, I will upload the documents to them, and then I have a collection system in place so that the actual final legal work is not delivered to the client until the payment is processed. So it's a simultaneous release of the work when I get paid. So that's for me, because again, I'm completely web-based, but a traditional practice has a virtual office component. It's just using that, online payment system, just like they would in office, I guess, to deliver the documents and receive the online payment.
Mike, did you want to add anything to that in terms of what you're seeing by way of billings and the approach?
I think your question was, what am I seeing? And frankly, I think, as Stephanie sort of said, the combination is the most common thing to do. The one thing I will just mention that Stephanie probably hasn't had to deal with yet, but at least is out there, and I think part of this because of Stephanie's practice, one of the areas that you probably have to examine if you are going to proceed down this road is most jurisdictions in the United States have rules that state that you cannot retain client work if you're not paid. And if, for example, if Stephanie were doing litigation work where something needed to be filed, you might run into a tension there that Stephanie, I suspect, doesn't normally run into. But no, and it's interesting also, I do a lot of work for lawyers. And the funny thing is that when you have lawyers as clients, very, very frequently, they will choose a non-hourly billing option, even if it's frankly quite a substantial fixed fee, that they like the certainty just like everyone else does. And I think that shows me a sign that I think that billable hour, while certainly we will continue to use in a lot of settings, is something that's really being challenged by a lot of fronts as well.
That was a stifled cry you heard from Chas as you were responding to that question. Jillian.
So this has really been terrific, just hearing about a lot of these different get out from under that set of regulations?
And that's a great question, actually, to do a whip, what I call in the British term a whip round. So let me actually go to each of the panelists to respond. Mike and Stephanie, did you hear the question?
Yes.
Okay.
I did hear the question, and I think the interesting example that I would give in response is one of the things that I always enjoy teaching is the restriction on non-lawyer ownership of law firms, which is pretty well established in the U.S. But you quickly realize that there are an awful lot of things lawyers and law firms can do to circumvent these rules.
Oh, yeah.
You can have a law firm where your highest paid employee is a non-lawyer economist. You can have an arrangement where you use a law-related entity that provides very similar services, and frankly, they really guide where the law firm goes. And I think that you're correct that perhaps these regulations are not a very high hurdle. The other thing I will tell you, though, is I've had a lengthy conversation with some of the actual regulators where they seem to believe things like the United States Constitution is not a very great restriction on when they go after people. My favorite example is the disciplinary counsel in Connecticut, and I appreciate his honesty, but he takes the position that if your website can be viewed in the state of Connecticut, that you are subject to the Connecticut rules. And I tried to discuss with him something called the Commerce Clause. He said, I don't think that affects things. If you can reach a Connecticut consumer, we can reach you. And I think that when you have that sort of thinking, it shows that the rules clearly create problems. And frankly, it is not uncommon for the Connecticut disciplinary authorities to send a long list of things you need to change in your website to firms. And usually it's a firm that has a Connecticut office, but I know one time it was a firm that had maybe 5% of its lawyers in Connecticut. But the Connecticut Bar Council have gone through every page and made suggestions as to the, New York admitted, New York only attorney and how his bio needed to be changed to comply with Connecticut law. And there's just a lot of hassle factor there. And the reality also is most lawyers know they don't want to get on the wrong side of the regulators. And so when we talk about prior restraint in First Amendment law, I think you're simply talking about prior restraint in adoption of some of these interesting technologies by lawyers.
Stephanie, to you.
I have to ask who we're trying to protect. Is it the attorneys and their jobs, or is it the public? Because some of these regulations that I think are doing perhaps more harm to the public and access to justice than they're doing anything else. Because our clients are clearly going online, seeking online services, and if they come up against, if it's difficult for an attorney to form a virtual office to provide that type of service, then I don't think it's hurting the client, the public. I know in setting up the virtual offices for other attorneys, they've had to do something. Had to send in the design of their website, show the online limited scope engagement agreement to the bar, get the approval of that, register the URL. It takes them 2 months or so just to set up a client portal in their virtual office. If the public can just go online and cut and paste together legal documents, it seems to me that as legal professionals, we really need to be stepping up to the plate to meet this need and finding ways to change the regulations so that they help us to do that. And here in North Carolina, I don't know that if you've heard the bill that was proposed here for alternative business structures, just I guess a couple of months ago. So we'll see what happens with that. But I know they're hopefully going to look at the UK and Australia and DC and see how it's been handled there. And maybe that's something that could change the legal profession here.
Chas, to you.
Wow. Yeah. I mean, Professor Rampenthal, I think you're right, and we've discussed this, privately. I've met with Richard Susskind about a year ago and chatted with him after a council called Generals of the Revolution, where he was talking to general counsels and how they're revolting against the high fees that even large law firms are charging now. And he said to me something that he said he stole from Bill Gates, which is the technology in the next year isn't going to change as much as you think it should, but in the next 10 years it's going to change way more than you ever thought it could. And I think the same thing applies to law. And I'm a new but pretty active member. I'm trying to be an active member in the ABA. I like what the ABA stands for. I take a look at the goals of the ABA. There are 4 of them. Under those goals are objectives, and the 4th objective under the 4th goal happens to be increasing access to law. I think that the ABA's had over 130 years to do it. I haven't seen a lot of that increased access happening. The way I look at it is if they're not willing to open up and understand what Professor Hadfield's talking about with the ABSs, that someone's going to do it without them. For instance, I think Renee talked about Quality Solicitors in her brief, which is a UK company that is trying to brand a national law firm. I'm actually heading on a plane tomorrow to the UK to be a part of the Legal Futures Conference and to meet with hopefully the people from Quality Solicitors as well as others. And it turns out that today I received a notification that Quality Solicitors is going to be launching what's called LAPs, Legal Access Points, in hundreds of W.H. Smith stores, starting relatively immediately. This people is a game changer. They estimate that once it's replicated, their test, if it's replicated across 200 stores, will result in over 1 million members of their legal access plan within the first year. When I read that, my heart skipped a beat. And it skipped a beat because I said, I want to do that. I want that to be for these consumers that we all have to deal with every day. And if it doesn't happen by the way of regulation like the UK did, it's going to happen somehow. And it's going to happen, like Mike said, by people figuring out ways around or to circumvent regulations versus actually just outright ignore them.
Dave, last word to you.
Well, I think the question is kind of aimed at what is called the Tesco law in the UK, and which was, will Tesco, which is like Walmart only in the UK, be allowed to set up or own legal services over in the UK? And Scotland, if I understand correctly, went up to the brink and just backed down. They got cold feet over the same sort of provision. But I guess there's a couple of questions there for me. Number one, is necessarily a bigger law firm one that's going to concentrate on providing services to the middle class or the lower class? I don't know about that. To me, when I think about this, there's a couple of impediments. One is perhaps the conflicts laws. Maybe the conflicts laws prevent firms from growing to a size where they would concentrate on all parts of the market, because right now they get conflicted out so many times that they can't grow. I've given that some thought. But I also think that maybe we're waiting for the Henry Ford of the legal market to come forward, the one that actually figures out how to do production line legal work to bring it down to a point where his own employees can afford to buy the legal car that he's selling. And maybe Chas is working at the solution, maybe ODR is working at the solution, but I think we have to continue to experiment from an economic standpoint and not allow the regulations to stand in the way of that experimentation to see 1,000 flowers bloom, and then we'll see where it goes from there.
And with that reference to springtime, I want to let you back out into it. But before I do, please join me in thanking all of our contributors today. Stephanie and Michael, thank you very much for joining us by Skype. Dave and Chas here on stage. To Jillian, to Renee, to Leslie, Patrick, thank you all very much for an incredibly stimulating discussion. Hopefully what we've done is actually given you a few questions, things to think about, and things that you want to explore as you're heading out, whatever practice you're currently engaged in or about to be engaged in. This is the world that's coming. Let's get ready. So in that respect, at least, join me in a round of applause to all of our speakers for today. Stephanie and Michael, I will hold up your virtual gifts, but they will be sent in. They will be sent in the mail to you. Let me also invite everybody who's here to join us for lunch. We'll be served outside. I'm cautioned or asked to remind you that if you happen to be taking your plates outside to enjoy part of that springtime, please bring them back in. There's no luncheon speaker, but our speakers will be available for discussion afterwards. Thank you all very much for coming.
Thank you, Paul.
Thank you, Stephanie.